Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome to our Cordell and Cordell podcast. The purpose of the podcast is to educate you on interesting family law topics and not to provide legal advice. To obtain legal advice, please set up a consultation with us. And to do that, contact 866-DADS-LAW or visit our website, cordellcordell.com. I'm Jared Ahrens, a management partner with Cordell and Cordell in our Omaha, Nebraska office. Today, we are going to be discussing alternatives to trial, an interesting and relatively complex topic. Specifically, we'll be discussing mediation, arbitration, and binding mediation. Many times, parties going through a family law matter assume the judge or the court are going to decide all the terms of the divorce, and so that's their concern. However, that's not really the case, and oftentimes that is not the case. The majority of the time, that's probably not the case. So we're going to talk about alternatives on how we can resolve our family law matters here today. And with me today is Jonathan Winn, litigation partner in our Salt Lake City area offices. He's also the lead attorney on our firm's appellate team. He's here to discuss our options to finalize your family law case without the need for a trial and having the court decide your fate. So with that, Jonathan, let's talk about our options, or our prospective clients' options on how to proceed without trial.
Yeah. Well, first thing to kind of remember, our Constitution has a provision that says, certain people have a right to a speedy trial. The biggest thing to understand is that does not apply in family law. That's a criminal constitutional right for a speedy trial. In family law, if a criminal wants a trial, he gets in front of you if you're in line to get in trial. So sometimes people get frustrated with how long these cases can take. And length usually means expense. It gets more and more expensive the longer we're getting pushed out. So people for years have been trying to find ways to get their divorces done quicker. How do we bypass this lengthy red tape of court and get this divorce settled? Now, there's been two ways that we've been doing this for years. They're tried and proven methods. And some people will use these terms and not really understand what they are. It's mediation and arbitration. So I thought we would start by just kind of talking about those two terms, and then we can kind of break into a third option that's just recently come about that's really kind of exciting.
Yeah, that sounds great. You bring up the speedy trial. It's funny just because these family law cases could take a month, 2 months. They could take 2-3 years. And a lot of that depends on these alternatives to trial, right? So talk about mediation. What are the pros and cons of mediation?
Yeah, mediation, it's been going around for a little while now, but basically when you have a mediator, you are hiring and you're paying out of pocket, both sides equally sharing that expense, a neutral person. And the role of this neutral person is they're not a judge. They're not somebody who's going to make a decision. Instead, they're going to facilitate conversation. They're going to help explore options for settlement. They're going to help explore compromises can be made. The good mediators really understand how this works. And like any profession, there's a scale within your community of the ones that are really good at it and the ones that just hung up and said, hey, I'm doing this, and maybe they don't close. But this neutral person, they're going to go back and forth between the two sides. Sometimes that's all in one room. Most of the time in a divorce setting or a custody setting, any sort of family law setting, they'll actually keep people separated. And they'll go in the room with the attorney and one client, and then they'll go in the attorney and the other client, and they'll explore their goals, their objectives, and look at ways we can cross over. In mediation, there's really two types of mediators. There's what we call persuasive mediators and non-persuasive mediators. A non-persuasive mediator, you can see this as somebody who's not even an attorney. This is just somebody who's just there to broker a deal, right? I mean, almost like a realtor, gets a seller and a buyer together and they broker a deal that makes everyone happy without any legal knowledge. A persuasive mediator is somebody who usually is an attorney. Many times they've been practicing family law, they're experienced, they have a good understanding of the alternative to that mediation, like what will a judge do if you don't settle your case. Many times we'll even hire retired judges as persuasive mediators, because then they can actually give a little bit of arm twisting in each room. They can say, hey, you're asking for this. I don't think you're going to get that. And that gives kind of a reality check. As a rule of thumb, persuasive mediators are usually a little better when you have another side who's making unreasonable accusations. If somebody's coming out with some things that are a little ridiculous and not normal, having somebody that's a persuasive mediator can kind of help that person or that person's attorney even recognize, hey, you got some risk here. You're probably not going to be successful in that. Maybe we can back off that position.
Who selects the mediator? How do you go about assigning a mediator? My experience, it depends on the jurisdiction. Sometimes it's the court's going to assign that mediator, but oftentimes it's the parties or the attorneys that select that mediator, correct?
That's right. I like, as an attorney myself, I want to be the one that helps select it. And I look at there's a lot of strategy, because at the end of the day, your goal and the goal of the other attorney is both attorneys want to resolve the case. That's the one thing that I have in common with my opposing counsel is we both want this case to get resolved. We want to have this family have peace and healing and be able to move on from this trauma they've been experiencing. So the other attorney and I will think about, okay, what mediator is going to best work for our family? We're going to think about our clients, about the issues in the case, how complicated they are, what kind of level of emotion we have. We're going to factor in the gender of the mediator, the experience of the mediator. Also, I factor in my opposing counsel, the attorney on the other side. Is he one that I've worked with really well and we can get a less expensive mediator because we know that two of us can kind of fill in? Or is he a really difficult attorney that I need maybe a mediator to kind of put him in his place? So there's not a kind of a one-size-fits-all answer. It really is tailored to your situation, which, by the way, I will make us clear. A lot of people go to mediation without attorneys, and that's not a good idea. The mediator cannot give you legal advice. Even if the mediator is an attorney, the mediator doesn't represent you personally. They want to get a deal done. And we see all the time people who make really bad deals because they didn't know any better. So you definitely want to have an attorney representing you when you go into mediation. If you think you can't afford to hire an attorney, that's a sign that you can't afford not to have an attorney.
Tell us about what someone can do to prepare for mediation.
That's a really good question. The more prepared you are for mediation, the more likely you'll settle. That being said, on one side, preparation usually means legal fees and expenses. And so there's a balance we're trying to do here with, we don't want to put as much money into a mediation as a trial, and then you're stuck with paying a lot of legal bills and having a lot of exhibits prepared. But on the other side, you don't want to be underprepared and not resolve your case in mediation. So there's a balance that your attorney and you will have to work through to kind of figure out the preparation. For sure, you're going to want to have documents prepared. We'd like to send out at least some sort of like a brief, like an explanation of here's the background of your case, here are your financial situation, here's what's going on if there's minor children involved. And then it's really helpful to know what the other side wants. And so the timing of your mediation, that kind of takes into that same place. Sometimes people want to do mediation a little too early in the case. Sometimes it's a little better to wait a little bit into the case, exchange some of the typical court documents, an answer and a counterclaim, responses, maybe your some financials before you get into mediation. So you're not mediating blind, but you really know what it is you're mediating.
Yeah, I have found the most effective mediations are when the parties are prepared, the attorneys are prepared, and they've provided a very thorough summary, maybe a financial statement, sent that to the mediator in advance. So the mediator's got that, and so we can hit the ground running as soon as we get in. And we'll know pretty quickly where this is going. Like, is there hope for settlement, or is this going to be kind of a lost cause, unlikely to settle? So one way or another, it's getting done quickly. The more prepared you are prior to mediation.
Yeah. Now, one of the biggest advantages of a mediation is the person who makes the decision is the two people. It's the mom and the dad. It's the husband and wife. Like, it's not a deal that's forced upon either of them. They make the decision. The benefit of that is when they make the decision, they're more willing to abide by that decision. It's not something that was forced down their throat. So you see less contempt. You see less enforcement issues later on because they kind of made their own bed and they're ready to sleep in it and they're ready to move forward.
Yeah, that's a great point. I've always told clients that essentially you're better off making the decision about your future than a third party judge that doesn't really know you or your family dynamics very well. Because if you go to trial, that a judge is going to listen to you, listen to some of the witnesses for a day, half a day, maybe 2 days, and determine your fate. Where you're fully invested in this, you've got the best knowledge of your situation, so you should be the ones making the decision.
Yeah, which kind of leads us now to the second alternative dispute resolution program. So that's the arbitration side of things.
Yeah, I don't know much about arbitration. I'm in Nebraska. I practice in Nebraska, Iowa. Not a lot of arbitration going on. So educate me and everyone else on arbitration.
It's interesting. Where you see this the most is probably like medical malpractice claims or big contract claims. Everybody knows that courts, they do a great job and it's a constitutional protection we have, but they're not efficient. They've got a lot going on. If people would stop committing all these crimes, free up our court system, we'd have a lot better court system. But that criminal side of it bogs down our courts. And so they contract to, rather than using a state judge paid for by our taxes, to basically hire a private judge. I mean, that's the easiest way to kind of describe an arbitration, is you mutually hire a judge. And so unlike a mediator who is just a facilitator of conversation, this person would essentially hear your evidence and make a ruling on your case. And then you're stuck with that ruling. Arbitration, most states have quite a bit of their own laws that have governing on what you can do, how you appeal that arbitration. Does it go back to court later? And so it's a fairly complicated situation, but in a nutshell, unlike a mediator who is a neutral, this person really is more like a judge. And so rather than saying, hey, Your Honor, we'd like a trial, and he says, hey, my next trial date, I just did one last week. He said, my next trial date is in March. And we're in August.
Yeah, right.
That's a long time to wait. And so in that case, I could say, hey, you know what? Let's hire retired judge so-and-so to be our private judge. He can get us in next week. Now, the pros of arbitration are your expenses are usually quite a bit less. You can, between the parties, it's a contract. So you can decide, do we have our clients testify? Does the attorney just give the evidence? Do we have to follow the rules of evidence, or can we get in hearsay evidence or documents? Do we have to call all the witnesses, or can we just have a letter from these people? And so you have some informal areas that can make it a little less expensive and a little quicker for your clients.
So you talked about costs a little bit. Real quick, can you touch on costs for arbitration versus costs for mediation? Is it similar? Arbitration more expensive, less expensive?
The people who do it, the mediators and the arbitrators, there's an overlap there. A lot of the mediators will do arbitration. A lot of the arbitrators will do mediation. So you're paying their hourly rate, just like you pay your attorney. And usually it's split between the two parties, 50-50. The preparation cost, arbitration, you're usually preparing a little higher because you got higher stakes. At a mediation, if you end up, if you spend a whole day mediating and you guys can't come up with an agreement, no harm, you move on to trial. Or you could even try a second day mediation later on after you do some more discovery or dig into one of the issues. Arbitration, it's a one and done. Like at the end of the day, that arbitrator is making a decision. So you want to make sure you are a little more prepared and cost and preparation are one and the same. So the more prepared you are with your exhibits and your evidence, your witness statements or whatever you kind of decide to give that arbitrator, there's going to be some additional cost.
Arbitration, you get a ruling. Would you call it a ruling? You get a ruling.
Yeah.
What's next? What are your options after the ruling?
Yeah. So again, very, very much per state, but majority of our states here would say that ruling is equivalent to what would happen if the judge had ruled it in the district court, in the trial court. And so you enter the ruling, and then you do your decree and you final findings, and then the court will actually sign off on it saying, yeah, we accept that ruling. And just like the court, if the court obeyed the ruling, there is some appeal options in an arbitration. So you can file an appeal if you disagree with the arbitrator. So there are some windows there to go up a level. If the arbitrator made a big mistake, you do have some protections there in arbitration.
Okay. When it comes to mediation and arbitration, just to kind of get people listening, get them a feel for it, I guess in my experience, everyone could be in the same room. You might have parties in separate rooms with the mediator, arbitrator in their own room. It varies, correct? Like based on what people are comfortable with.
Yeah, and that's where it's kind of nice because you can tailor the environment to best meet your needs. Now, arbitration, it's much more likely you're together because you kind of have a right to dispute what's being said. You know, if they're saying something and that's not true, you have the right to hear what they said and provide rebuttal evidence. Mediation, on the other hand, is more typical to be in separate rooms, to be apart, because then you can really explore options with the mediator freely in a confidential setting. Speaking of confidentiality, that is one positive that we have in mediation. Everything that's said, everything that's done, every offer that's made is completely confidential. You can make admissions in mediation or explore options of settlement. And if it doesn't work out, they can't go to the court and say, hey, well, he offered me full custody here if I only gave him this. Like none of that can come out later. So it does allow kind of this protection of really exploring everything, turning over every rock to see if there's any middle room we can make.
Okay. All right. Moving on to last but not least, another option to avoid trial and resolve your case is binding mediation. Also something I'm not too particularly well versed in. So explain that to myself and explain that to those listening.
This is very new, very new thing. You're not alone in not recognizing this. I mean, the first we really heard about it was in 2006. There was a Supreme Court case coming out of California. It was the Lindsay case in California, where they talked about this concept of binding mediation. Really what it is, and for years, people have tried to kind of find a hybrid between arbitration and mediation. There's some, like we mentioned, there's pros and cons to both. And so this is kind of new. That the ABA, the American Bar Association, has now come out and said, hey, yeah, that we accept this as a rule. A lot of people were hesitant to go down this because they were afraid to try something new until the Supreme Court's come out, and if there's been a few cases now. So now it's starting to pick up some ground, starting to move. So what it is, and I'm actually really excited about it. I've done several of these now, and they're great. It really is the baby of arbitration and mediation put together. So you start the process with the mediator and you go all day. And then you basically by contract say, hey, if at 5 o'clock we can't reach a decision on our own, we give the mediator authority to make a recommendation and we agree to adopt that recommendation. Now, unlike arbitration, you don't have a right to appeal it. Because now you're actually agreeing to accept whatever that is. So there's some danger there, and you're putting a lot of trust in that mediator because they're in a role. And there's not very many mediators. A lot of mediators don't understand the process. You got to be really careful who you find. It puts them in kind of a weird position because they're neutral for the first half of the day. Then the last half of the day, they switch their role completely. And they become essentially like an arbitrator, very similar role of now they're going to make a decision. Where I found that it really is helpful is if I know, for example, I'm trying to push a certain issue and I feel like it's a strong issue. Well, if at 4 o'clock, we're just not getting there, the mediator could come to me and say, hey, Jonathan, just so you know, at 5 o'clock, I'm not buying this position. I get where you're coming from, but I'm not on board here. That may change how you make your next offer to the other side in the next hour.
And you don't get that trial. You don't get that trial.
Every once in a while, a judge may do a pre-trial conference similar, right? You get the judges
right.
kind of, hey, you're trying this. I don't know where you're coming from on this. But that feedback from the mediator, what happens is our settlement rate, most of these cases, they don't ever get to the decision-making side of it, because the mediator now is a very persuasive mediator, because they know, hey, at the end of the day, I'm going to make a decision. So the mediator can really twist your arm. I had a case about a year ago with a retired judge, and he came back into the other side. We'd made an offer, and it was a financial number. And without getting any deal, let's just say we said $100,000. And the mediator went into the other room and said, hey, look, they're offering $100,000. Just so you know, if you guys don't settle today, that $100,000 was a compromise. If I had to rule on it, I would rule 150. So their deal is actually better than what I'm going to give you. Now, part of that reason why the mediator is doing something like that is because they don't want to make the decision. They really do want you to mediate it and not get to that, okay, we didn't mediate it, now you're the arbitrator, now you're the adjudicator is probably a better word for that. And in that case, they took the deal. They said, you know what, knowing kind of where we're at, we'll take their compromise number as opposed to having to pay a higher number that's going to be an adjudicated number.
Yeah, and then you also, they might hear that from the arbitrator, mediator, and just say, "Hey, I want my day in court." They get that. Well,
the thing is once you contract to the arbitration mediation, that's it. Like, you're done that day. So one of the great benefits of it, there is no appeal. Most of the time, there's no appeal. There's no rules of evidence. It is a one and done, and you're done. So it's great. You don't have to worry about legal fees. You don't have to worry about trial. You don't have to worry about appeals. You don't have to worry about this dragging out for years. You go in and at 5 o'clock, you're done, for better or for worse. If you guys can't make a decision, the mediator will make a recommendation, and you're tied to that, and that's it. And so that is one of the great benefits. One of the places I see this probably used the most is not just in a whole on trial, like a divorce or a custody dispute, but the little things. This is a great tool. If you've got joint legal custody with a spouse, and you have to decide, do we put our kids in braces or not? You hire a binding mediator. You do a 10-minute, hey, here's why I think they should get braces. Your spouse does a 10-minute, here's what your ex-spouse, here's 10 minutes why they shouldn't. You talk about it for 10 minutes. You guys can't agree. Mediator makes a decision, you're done. And you pay them for 1 hour of their time, and it's resolved. You don't have to go to court. You don't have to, it could be, which school do we put our kids into? Dad's school or mom's school? Go to this binding mediation, hour, day later, you're done. No attorney's fees, no trials, no, appeals.
Very efficient, right? Less back and forth between the attorneys, racking up legal fees, and avoiding the court, which will take, a lot of time and a lot of money. Yeah.
Now, I think we're right now kind of, I would say, on the cutting edge of what binding mediation can do. I would venture to say 99% of the people listening to this podcast probably have never heard of this new alternative dispute resolution, including attorneys and judges even. And so I'm excited to see where it goes, recognizing there are pros and cons. I'm excited about it because I've had some great successes with my own clients where I've saved them a lot of money. But like I said, with every process, there are some challenges. I mean, you don't have an appeal right. You don't have some of the protections of our evidence rules and our civil procedure rules. And so sometimes it could work out bad. So you want to really carefully evaluate with your own legal counsel which of these three, dispute resolution processes will work better versus maybe even route 4, which is you just go straight to trial and you just do the grind and get there.
Yeah, and it's not uncommon in a lot of jurisdictions where one of these three is going to be required by the court, right? They're going to make you do some kind of alternative dispute resolution prior to setting for trial. So it's something to think about and consider, immediately to get out of the way, check that box, but also to have a big part in deciding your fate and your future with your decree.
Exactly. Yeah. And, just thinking about that, one other option you also see is what we call a judicial settlement conference. Now, again, maybe different jurisdictions do a little differently, but it's a kind of a hybrid in a way of a mediation where you have a sitting judge weigh in on it sometimes to help the judge across the hall kind of decrease his caseload. And so some of that is an option. I see that happen too. But The important thing, if you're listening to this podcast, is know that there's options before you. You're not just stuck paying for a long, drawn-out battle of litigation for years and years and experts and all that. You have some options. And so consult with your attorney, explore the options, figure out what's going to be best for you, because there are less expensive and more efficient ways to get this done than just the typical trial.
Absolutely. Yeah, and what's exciting for Cordell and Cordell is we are now offering mediation. Visit our website to set up a consultation regarding a divorce case, custody case, or even setting up some kind of mediation. We've got mediators throughout the country. It's something we're now offering. And to set that up, again, contact 866-DASLAW or visit our website, CordellCordell.com, and we can assist you with litigating and mediating now. So very exciting. And we hope to grow that practice within our firm and help people get their cases resolved one way or another. Anything else, Jonathan?
No, I think it's really exciting doing mediations. I think our attorneys in particular have a really good, strong background for mediation. I mean, these attorneys are people who do this because they want to find peace. They want to heal the family. And what better way to do that than to be a neutral where they can be right in the middle and they can try to find a compromise and help this family move forward. Really excited about that. We're happy to help you if you need some help.
Yeah, no, you're exactly right. When these things go to trial and the judge has to decide, it is bad for everyone. It's very, very expensive. And then also the parties are more contentious after separation, after divorce, than they would be if they resolved it on their own, is from my experience. So highly recommend exploring these alternative dispute resolution options, and that's something we can assist with. But that's it. That's it for today. And have a great weekend.